Did you know that if your business partner passes away, the IRS in essence can tax the deceased partner's life insurance policy? The Supreme Court recently issued a unanimous opinion in Connolly versus the IRS. This ruling resolves a common estate tax issue for closely held corporations in favor of the IRS. Over the next few minutes, I'm going to share with you what you need to do in your best interest for your family's business. Hi, I'm Mitch Greene, a partner at Kramer Greene for the last 30 years. I've helped business owners in various industries protect their businesses from unforeseen circumstances. If you're trying to protect your assets or business and need legal assistance, I'd like to help you create that playbook. So visit my website and schedule a complimentary consultation, and I could walk you through your options. The Supreme Court's decision created various estate planning opportunities to avoid placing an increased estate tax burden on the owners of a closely held corporation. Closely held or family corporations routinely buy life insurance policies ensuring the life of the corporation's principal shareholders. When a shareholder passes away, the life insurance policy proceeds allow the corporation to purchase the shareholders' shares to keep control of the corporation within the original family. But here's the problem. This situation creates an issue as to how the life insurance proceeds impact the value of the corporation when they flow into the corporation just after the shareholder's death. From one perspective, the insurance proceeds increase the corporation's value by the amount of the proceeds. From another perspective, the corporation should stay at the same value as the corporation immediately utilizes the insurance proceeds to purchase the shares of the deceased shareholder. In the Connolly case, the brothers Michael and Thomas Connolly were the sole shareholders of a building supply company. Michael owned 75% of the corporation's shares, and Thomas owned 25% of the corporation's shares. The brothers had a buy-sell shareholders agreement stating that the surviving brother could purchase the shares of the deceased brother if either brother passed away. Michael passed away first. Therefore, the corporation utilized the $3 million policy which it owned on Michael's life to purchase or redeem those shares that Michael owned in the corporation. At the time of Michael's death, the corporation was worth around $4 million as an operating business. The corporation reported Michael's shares worth about $3 million, or 75% of the $4 million value. However, the IRS took the position that the corporation was now worth $7 million due to the influx of the insurance policy proceeds. In this case, the Supreme Court held that since the corporation shows a structure by which the life insurance proceeds would pay out to the corporation upon the shareholder's death, the deceased shareholder must be taxed on the increased value of the corporation resulting from such insurance proceeds. Here are some steps you can take in light of the Connolly decision. First, you should review the structure and terms of your existing shareholders agreement. If your shareholders agreement uses company-owned life insurance, the Supreme Court decision affects you. If the value of your estate is safely under the federal estate tax threshold, which is currently approximately $13 million, you may want to leave the insurance-funded redemption agreement in place. Even though the life insurance may add to your company's value, no federal estate tax would be due if you're under the estate tax exemption limit. However, please note that beginning January 1, 2026, the federal estate tax exemption will be cut in half. You may also want to change your arrangement to a cross-purchase agreement. Here, each owner buys life insurance on the other owners and uses the proceeds to purchase the shares of the deceased shareholder. With this type of structure, the value of the insurance does not affect the company's value as it did in the Connolly case. Changing an existing redemption agreement may prove difficult because of the number of life insurance policies that may be involved if there are more than 2 or 3 shareholders. If you're concerned that not all the owners will pay the insurance premiums to keep the insurance in force, or that the number of owners is too numerous to monitor effectively, you might consider a cross-purchase trust or an insurance LLC. The advantage here is that rather than having each shareholder own policies on all of the other shareholders, there's only one insurance policy per owner. Whether you're trying to protect your assets, start a business, sell a business, or navigate the law within your business, we provide a one-stop shop for everything. If you have questions surrounding your business and legal needs, schedule time to meet with our firm today and take the first step in protecting your business and financial future. If you like this information and want further information whether on this topic or other topics of interest, please subscribe to our YouTube channel.